Hey, good morning, Choice Residential. Hope your day's off to a wonderful start. So today I want to talk about encroachment agreements. Now, let me start by saying anytime things start to get sticky with encroachments or easements, it's always best to have an attorney weigh in. It's why we've got the team at Sterling Law to help anytime we have sticky situations. But I want you to have a basic understanding, at least, of encroachment agreements, when they might be necessary, and what different types of language we might see in encroachment agreements. So typically this is going to be a solution when your client has a survey done, or maybe you're on the listing side and there's a survey done and there is an encroachment. Now, an encroachment could be anything from a fence that encroaches a few inches, or we've seen it be as dramatic as a home was actually built over the property line. That's a much more significant encroachment that is going to need a different solution other than an encroachment agreement. But oftentimes when we have relatively minor encroachments, we can handle that with an encroachment agreement rather than having that encroachment actually moved. So if you think about a fence, maybe the neighbor's fence is encroaching on our subject property by 6 or 10 inches. One solution, of course, is to have that neighbor move the fence. But maybe everybody involved says, well, that's not really necessary, but we want to take proper legal precautions to make sure that that land can't be claimed through adverse possession, that we understand who is maintaining that fence, and we understand what the recourse is for future transactions when one of these properties may be selling. So an encroachment agreement is a way to do that. One version of an encroachment agreement will say that that encroachment is allowed to remain in place. So both parties know that it's there, both parties being the person who owns the property and the new buyer, as well as the neighbor. So we all know that the encroachment is there, and I'm giving you permission as the property owner for that encroachment to exist on my property. And I'm going to give you permission until some future date in which I or a future property owner of my property decides that I no longer want it there. So it is more or less a temporary encroachment agreement saying, hey, it's there for now, but if for some reason I ever need you to move it later, you are agreeing as the neighbor or any future owner of that neighbor's property, you are agreeing to move that encroachment. This document would get recorded. It would be public record. Any future buyer or attorney would be able to locate that encroachment agreement. Another version of the encroachment agreement, though, will be more permanent in nature, and it will run with the land, meaning that that encroachment, we are given permission for that to be there now, and it is going to be there until the time that that encroachment just naturally doesn't exist. So let's say it's a fence that gets eventually corroded away, or a tree falls on it. That neighbor then may not be able to put that fence back onto our property. But until such a time, it is allowed to stay there. I, as the subject property owner, cannot tell that neighbor to move the fence in a year. When I go to sell the property, that person that I might be selling the property to, they don't have the right to tell that neighbor to move the fence in this example. So there can be different versions and language in these encroachment agreements. So it's important that you understand that they're not all created equal. And depending on who you might represent in a transaction, you may have different advice. But this is why you always want to get it to an attorney. Of course, an attorney is going to draft these agreements, but you want to be aware that they can say different things. So keep that in mind as you figure out how to advise your clients. Also, just want to mention a little bit about the logistics of getting that done and whose responsibility it is. Typically, as the seller of a property where there's an encroachment, so whether it's my property encroaching onto a neighbor or a neighbor's property encroaching onto my property, if I'm selling, the burden is typically going to fall on me. And of course, as you might expect, my agent to satisfy and get that encroachment agreement. That's going to typically require going and talking to the neighbor to get their agreement to sign that encroachment agreement, because that's who it's going to be between me as the seller and the either impacted neighbor who I'm encroaching on their property, or they're encroaching onto my property. Both of us will need to agree to and sign that encroachment agreement. So a seller or a listing agent will typically need to go contact that neighbor to get that agreement and discuss what that means. Typically, if it's their property encroaching onto mine, they're going to be okay with it because it means they don't have to move their fence. If it's the other way around, they may say, no, I want your fence off of my property. I'm using fences as examples, but there can be any number of other things that cause encroachments where an encroachment agreement may be warranted. But again, when in doubt, reach out to me. We can talk through the specifics of your scenario And of course, always talk to the closing attorney to understand what legal implications go along with this. So if you have questions about it, as always, I'm just a phone call away. Until next time, take care.